Hello, everyone. This is Michael Luter. I'm the chair or co-chair of the Foley and Lardner Consumer Financial Services Litigation Practice Group, and we're delighted today to present another session of the UDAP Council web conference series. The UDAP Council is a forum for the consumer financial services industry which focuses exclusively on UDAP and how to manage Dodd-Frank requirements and develop strategies to help ensure compliance with those provisions. As a council member, among other things, UDAP council members have an opportunity to participate in our web conferences and to receive breaking news, updates, and exclusive analysis of UDAP-related legal developments. Before we get started, of course, I need to show you this, which is a disclaimer saying that what we say today is not legal advice, and that legal advice must be tailored, of course, to specific circumstances of each case. But with that, let me get going here. So the UDAP Council presentation today will feature 5 of our lawyers, and we also have 2 guests from the State Attorneys General governmental entities. The first person I'd like to introduce today is Joe Jacquot. Joe is going to then introduce our other speakers. Joe is a partner and a business attorney in our Jacksonville, Florida office. He represents clients in complex federal and state legal and policy matters. He counsels companies in the financial services regulatory on financial services regulatory matters, and really any matter that involves the State Attorney General. His practice includes a wide range of matters, including investigations, litigation, federal agency action, and crisis management. He spends a lot of his time just developing and keeping deep ties with AGs nationwide, as well as with Congress. So for our first part of this program, I'll turn it over to Joe, and then he'll flip it back to me, and we'll give a short UDAP update, just kind of on the current developments. But with that, I turn the session over to Joe Jacquot to introduce our speakers.
Hey, thanks, Mike. So today we have 2 folks here. I'm first going to introduce my friend, Sean Riley. Sean is in the Kentucky Attorney General's office. That's Attorney General Jack Conway. And Sean has been the Chief Deputy Attorney General since 2012. He was previously the head of the Civil Litigation Division in the Attorney General's office. And Sean is a graduate of Columbia Law School. He also has political experience working on 2 Senate campaigns, Jack Conway's campaign and John Kerry. And next we have Jessica Whitney. Jessica is in the Iowa Attorney General office, and that Attorney General is Tom Miller. He's the longest-serving AG, and Jessica is an assistant AG and deputy administrator of the Iowa Consumer Credit Code, and she's been involved in a number of issues involving financial services and mortgage issues. She's a graduate of the University of Michigan Law School, and I haven't told her this yet, but I saw General Miller last week. I spent some time with him in Chicago, and he told me that Jessica is a, quote, star who keeps rising. So I'm very pleased that both of them could join us today. Hey, let me just make a couple initial comments, and then really what we're going to do is just have a dialogue. I've got some questions to pose to Sean and Jessica, and you're welcome to email me questions through the webinar throughout this next 20 to 30 minutes. But I want to say just 3 things to kick us off. So one is state attorneys general have the ability to bring cases on behalf of the public interest. So this is more than just the ability to sue on behalf of the state or a state agency. It's the ability to bring cases for the interests of consumers generally across the state. So first point to keep in mind. Second is that attorneys general can join forces in other multi-state investigations and enforcement. So they can work with other states on the same case, whether that's through the investigation period or ultimately in a settlement. And then third, every state has some version of a UDAP statute, and that really is a common platform for AGs to pursue cases and remedies. So we're talking today, obviously, about one of the most prolific areas of AG action, and that's unfair, deceptive acts and practices. Okay, so let me launch into it. So this question I'm just going to toss out for Sean, for you or Jessica. You could both answer, and that is, your offices have really been on the forefront in multi-state efforts in the for-profit college arena, in the mortgage industry, and other areas. And so describe to us a little bit about the process you go through when you're initiating these kinds of significant multi-state actions. And maybe you can just even start off with where, how do you get complaints? Where are the sources of those cases?
Sure. This is Sean. I'll take a stab at that first. But I wanted to first thank you, Joe, and Mike, for inviting me and Jessica to join you today, and thank Foley and Lardner for the opportunity to speak with all of you. Before I start, I just want to give a brief disclaimer of my own, that any of the opinions I give today are my own, and they are not the official opinion of the Office of the Attorney General. Some of the subjects I may discuss today involve pending litigation, and so I will do my best to give you an objective read on what's happening in any of those pieces of litigation. But to get at the question, Joe, there's a variety of ways that sort of large multi-state enforcement efforts come to be. And in preparing for this today, I kind of put them into three buckets of how this information gets to us and how attorneys general then process it and make a decision to join forces and bring something in a multi-state capacity. The number one way we receive information about corporate misconduct that might lead to a multi-state is through consumers, through our own constituents. We get on a daily basis any number of calls complaining about what is perceived to be an unfair business practice, deceptive, within the state. By and large, these run the gamut. We always get complaints about gas prices, for example. But for the for-profit colleges, for Kentucky in particular, this really was the way that we were turned on to this area of misconduct that we've been working on for several years now. It really all started in the western part of the state. There was a private law school in Paducah, Kentucky that failed. And as a consequence of that failure, all of its students were left sort of in a very gray area of how to proceed, how to recover the money they had spent to matriculate at the institution. They are left in a situation where they had non-transferable academic hours received. And so it really was an eye-opening experience for our consumer protection attorneys to navigate that process with these students who were basically out of luck with no credits and significant amount of debt. And that happened at the graduate school level, which is unique when we talk about some of the typical undergraduate for-profit schools that we've been looking at. So that it really is one of the ways that the primary way that we can become aware of potential misconduct. As we looked into the failure of this law school, we began to notice similar conduct in some of the for-profit schools operating in the state, of which there are approximately 150. So really in the for-profit college space, we got keyed into that based on our own consumers calling into us and telling us what they are experiencing. The other two ways I think that we sort of get into multi-state investigations is either by crisis. So, for example, the 2008 housing crisis and foreclosure crisis is certainly, I think, something that precipitated the subsequent national mortgage settlement a few years later that General Miller, and Jessica probably has a lot more information on this, spearheaded. And the third way we sort of get into multi-state activity is, I would say, policy-driven, and that is when AGs get together and they have a particular area that they traditionally focus on. And one of those, for an example of that is protection of children. So when you have a common policy area that is most AGs, regardless of political party, are paying attention to protecting children, that tends to provide a common ground for them to root out corporate misconduct that is potentially in violation of state consumer protection statutes. So examples of that are marketing to children. For example, 5 Hour Energy, there's an ongoing multi-state where AGs have alleged that they are misleading in their marketing in terms of what's contained within the product and its a safety profile. That also includes multi-state efforts into technology companies that children can access, such as Facebook and Topics. And it also, one of the recent examples is worker misclassification, where large corporate entities misclassify workers as independent contractors in order to reap some tax benefits. And that's an area that AGs have worked on collaboratively for years. Most recently, there was a multi-state effort against FedEx Ground for worker misclassification. So those are some of the main ways that we start to notice activity that could give rise to a multi-state.
Hey, thanks, Sean. Go ahead, Jessica.
Oh, yeah, no, I was just going to add just a couple quick things, and first also extend my thanks, and thanks to General Miller for those kind words, and thank you, Joe, and everyone at Foley, and folks on the line. And also, caveat, these are my opinions, not A.G. Miller's. And I would add about sources of complaints, and I think those 3 categories that Sean laid out are excellent. But that folks can also see things like, I know A.G. Miller is very active, and if he sees something or he's reading about something that he thinks is wrong, or he sees an ad that he thinks is wrong, that comes up too. And I would say that sometimes the sources of complaints, especially the consumers, don't necessarily understand what they're complaining about. If we want to take it back to the mortgage situation, we were getting complaints. I started in this office in 2004, and we were seeing complaints, people having housing problems, and they didn't know what they were complaining about, and they would just say things were unfair. But looking at them, we would see inflated appraisals and stated income fraud going way back to 2004, and we knew the crisis was coming, and just getting folks on board. So I think that complaints can come from many ways. Talking with other regulators, again, that's under Sean's sort of policy division, in times of crisis, and definitely consumers and what we see out there too.
Yeah, okay, so that makes me think a little bit, Sean, just about the actions I've seen you and General Conway take, as you mentioned, in the for-profit space, and particularly, I saw you teaming up with the Florida Attorney General, where I used to be the chief deputy. I believe that you've been involved to some degree with the Department of Education, which is going through a rulemaking process in this space. Certainly the CFPB has relationships with state AGs. The former AG of Ohio, Richard Cordray, is the director, and there's authority that you certainly have in relation to the agency. And I believe that General Conway and you have even led some discussions with members of Congress. And I think all that is important for this group to know, that state AGs are certainly looking out for the interests of their state residents, but they're tied into a larger network, as you said, policy-driven, trying to solve problems. So maybe each of you could talk just a little bit about the multi-state context. When things get bigger, what are those relationships between states that can really drive the largest cases?
Sure. This is Sean again, and really the thing about the AG world, and Joe, you know this just as much as anyone on the call, is that there are 50 AGs. They're bipartisan, but they tend to have a collegiality between them that really, I think, benefits their individual offices and their respective states. So a lot of the issues that come to get on the radar screen of AGs, if you will, they are cross-pollinated and informally from AG to AG. For example, General Miller and General Conway have developed a friendship, both personal and professional, in the 8 years that Jack has been AG. And there really is nothing that beats Jack picking up the phone and calling Tom and saying, you know what, this is something we're seeing at for-profit schools in Kentucky. Are you seeing the same thing? And lo and behold, General Miller finds out that he is seeing the same thing in Iowa. And that's sort of one of the tipping points, if you will, for when a multi-state investigation starts to snowball. So there's this informal process at the beginning where you really have the constitutional office holders in each state, for example, General Miller and Joan Conway, talking about a problem and sort of talking about what they're seeing between their states. And then the next step, I think, is an interface with similar federal agencies. As you mentioned, in the example of the for-profit schools, we have made significant headway with working with Secretary Duncan, Department of Education, and Richard Cordroy at the CFPB. And so a lot of the process is informal. It's staff-driven. It's also principal-to-principal driven, where you're highlighting and you're sharing information about what this misconduct is that you're seeing and what are possible equitable or other ways that we want to address that. At some point, the process becomes more formal with the issuance of CIDs and potentially even litigation, where the information sharing becomes a little bit more formal and subject to rules of procedure and confidentiality provisions. And that is when the multi-states tend to get more formal structure. But really, you start out in an informal, sort of almost colloquial way of talking about a problem, and then it evolves into a more formal structure where you're talking about CIDs and software that where you have shared. For example, in for-profit investigations, for-profit college investigations, some of the larger publicly traded targets that we've been investigating with our sister states, on any given day, each state will drop the same CID on the target. So the target will receive 8 CIDs that are pretty much identical. And that initiates a process where that target is going to be collecting and retaining and producing documents to each of these 8 states. And then it becomes a question of managing the process, whether there's going to be 8 productions to 8 offices or whether there's going to be a common production to a common software interface. But all these sort of things evolve as a multi-state progresses. There's really no cookie-cutter approach, but the general thing is that it starts very informally through sort of the common professional kinship of AGs, and then it evolves to join federal partners and formalize into a more legit posture.
That is some great insight, and I think it is an example of why AGs have not just significant influence in their states, but can really push national agendas. So let me ask you, Jessica, kind of your experience on the same lines that Sean described, particularly with the mortgage industry, because I know you were involved and are still involved in some of the post-mortgage crisis cases. I mean, obviously, I think everyone on this call knows that General Miller was the one who really led the $25 billion settlement among the 5 banks, and as a result has brought some changes in how that business runs. So give us some thoughts that you've had from your own experience with multi-states.
I think Sean did a great job of sort of summarizing how these things come together. It's not always the same. It's a lot of interpersonal relationships, too. Like Sean said, it can be principle-driven with the AGs talking to one another, being good friends. It can be staff-driven. We have, a National Association of Attorneys General, the great acronym NAG, that allows both AGs to get together themselves on the principal level, but also the staff to get together, form relationships, form groups that focus on certain issues, for example, mortgage issues or financial issues, have working groups, telephone calls where we keep each other through email, whatever means, updated on what's going on. And I think you saw both at play in response to the mortgage. You saw Tom taking the lead and an interest in realizing how critical this was going to be, and then staff talking with one another about what we were actually seeing on the ground, which, like I said, in the early years wasn't necessarily getting reported. We were kind of laughed at in 04, 05, 06. When it was booming, no one believed us when we said we see bad things coming. We're starting to see them at the complaint level. And so you really saw an interplay amongst staff, and it was slightly different in different parts of the country, with how the booms were going. In sort of Florida, say, versus Iowa, the frauds were different, but we were able to talk to one another and recognize what we were seeing and work together. And you have a good relationship with your AG, and you're able to tell him or her what you're seeing, and then they also talk. And you also have relationships at federal and state agencies, again, with sort of staff level, and your principals have it more on the principal level, and it really works to facilitate figuring out what is actually happening and getting your hands around something sort of as complex as, say, what was going on in the mortgage world.
Okay, so let's take that, which, I mean, in and of itself, a multi-state can apply tremendous pressure. And let me ask some questions about your relationships with federal agencies, because you kind of layer on top of that what the AGs do, whether it's with DOJ or the FTC or the CFPB, or, Sean mentioned the Department of Education on the for-profit. I mean, there's a host of federal agencies that you may have partnerships with, whether through the national organization NAG or whether it's just your enforcement of federal law. So I'd be curious if one of you could speak to either the relationship, maybe a case that you've worked on with the FTC. I know there's a database that AGs share with the FTC for consumer complaints. You certainly have joint enforcement actions, so a little bit of that relationship with the FTC, or with the CFPB and some of the new things that might be coming in terms of AG cases in conjunction with the CFPB that we haven't seen as much in the past.
Sure. Jessica, I'll go ahead and I'll start with FTC, and maybe Sean can take CFPB, or we can flip-flop. It doesn't matter. We work closely with both of them. I think the FTC relationship goes way back. A lot of state statutes that, the Unfair Deceptive Acts and Practices statutes are called little FTC acts because they were sort of copying or aping the FTC statute. States have long worked closely with the FTC. We share information. As you mentioned, there's a complaint database that FTC keeps active, and states can upload their complaints as well. And then if you are uploading your complaints and have access to it, you can search. And you can search by state, you can search by company, and see what's going on. I think there's long been this close relationship. And again, regardless of party lines, it's not partisan. It's sort of been just a sort of common goal of consumer protection. And you can work closely with the FTC. We can either be all looking at an issue, say, for example, mortgage foreclosure rescue, if we're going to focus on mortgage. So those real scammy foreclosure rescue companies that I think do everyone a disservice, from the lenders to the consumers. There were so many of them, right? It's like whack-a-mole. They pop up overnight, that it didn't necessarily make sense to focus on one or two, but what made a whole lot of sense was for the FTC to go after as many as they could, and the states to do so at the same time, sharing information, using that complaint database to see which companies were most active in your area. Again, working over email, figuring out what sort of just general tactics worked well at going after these companies, and then maybe doing something and announcing it all at the same time to have a very large impact on this sort of, I want to call them a very legitimate industry, but this industry, and let them know that, not only was the FTC looking at them, but, over half the states were looking at them and taking action as well in the same time. Alternatively, we can work closely with the FTC and bring a joint action, which we've also done in the past, where we have common interest agreements. It's much like working with the other states, and we work together, and we're in the room at the same time, and we both have our own areas of enforcement, and we work together. I think it's a little bit easier on the company when that happens because they're not, trying to face a war on two fronts. You get everyone in the room at the same time, and you hopefully get one universal resolution, and you're not battling two folks. And it's easier for us because we have more people looking at it and more resources. So I think they're win-wins when the federal folks and state folks work together. So that's the FTC. Sean, if you want to do CFPB, or I'm happy to do it too. So.
Sure. I mean, I think just to follow up on Jessica's comments on the FTC, we have an exceptionally good relationship with the FTC, and what they also, in addition to tracking consumer complaints, they have, when the rubber meets the road, they just have a tremendous amount of expertise when it comes to litigating certain complex consumer frauds. For example, we recently worked hand in hand with the FTC on one of the largest pyramid scheme corporations in America, Fortune High Tech Marketing, which was based in Lexington, Kentucky. And without partnering with the FTC at the outset, we would not have been able to make the economic case, put on the economic proof that this company was indeed a pyramid scheme. And so it was that partnership from the outset that really created a successful outcome there. In terms of the CFPB is in many ways still figuring out, I think, itself. But that's not to say that the AGs have not really embraced the potential jurisdiction of the CFPB, particularly when it comes to the for-profit college space is where there's been tremendous synergy thus far. And then also with online lending and payday lending, as the CFPB continues to flush out potential new regulations for each of those sectors. But they have been really a true partner when it comes to the financial interaction that for-profit schools have with their potential students. For many students who choose to matriculate into for-profit institutions, these institutions often offer private loans provided by the school itself. And there have been significant questions of transparency and disclosure about what students are told when they sign on the dotted line to take out these enormous amounts of private loans from these colleges, with little to no correlation about what their job prospects are if they even complete the program. So the CFPB has really helped us to put a little more gusto in this effort, and I think that and particularly with Director Cordroy, who is former AG of Ohio, he really gets it, and so he's really trying in his tenure to give the agency some teeth. And I think in terms of relationship with the AGs, it's one that's going to continue to evolve, but so far so good.
And I would add with the CFPB, it has been excellent on all fronts on several different lending areas. They've always made sure to seek our input. And I think because of the legislation that created the CFPB and the Dodd-Frank Act in general, AGs are sort of meant to have a special role with CFPB. Dodd-Frank giving the AG some authority, it sort of naturally makes us partners in certain areas. And much like Sean pointed out, the FTC has expertise. The CFPB also is developing their own expertise and has lots of experts on different issues and has far more resources than some of the states, than most of the states, I would say. And it's good to be able to access those and to have a very solid working relationship with the CFPB.
Hey, let me pick up there, and we're on the home stretch, so if anyone's got a last minute question, feel free to go ahead and email that in. But let me ask you about something you just mentioned, Jessica, and that is, with Dodd-Frank and with the authority that AGs have in enforcing the federal UDAP standards, the ability to enforce CFPB rules and regulations, along with the clearing out of some of the traditional preemption that AGs had in the financial services area. So that came through the Cuomo case, as well as that in the Dodd-Frank statute. Are AG offices building up and ramping up experience in their attorneys for the financial services sector? Is that something that both of you are seeing now, that you really have the ability to get in and drive these cases?
I would say we had the experience before. We were fighting preemption for a long time, right? And we kept saying, you had the whole Wachovia line of cases, that we had more authority than maybe we did have, especially until Dodd-Frank. I definitely think Dodd-Frank was sort of the watershed moment. It gave us sort of clear authority, specific authority over national banks. We've always done sort of financial regulation within our own states, and state banks and state lending, non-depository institutions. That's part of my administrative role. So I think we've always had that financial services expertise area. It's just been broadened to definitely include national banks. We are learning a great deal from CFPB, and where we can, we're working closely with CFPB. I think at this point, though, states have only brought maybe maybe it's five UDAP cases, or Dodd-Frank cases under the Dodd-Frank Act. And I don't think they've been solely Dodd-Frank cases. I think they've just tacked on a Dodd-Frank claim here or there to get jurisdiction. But I think it's definitely, the Dodd-Frank Act has definitely brought AGs to the forefront. And if nothing else, I think it's given companies a different, something to focus on, whereas before they were maybe trying to swat us away. And not always. Lots of financial institutions have worked with us. But now I think, we do have a seat at the table, and we're someone I think you should definitely think about when thinking of enforcement.
Yep. Well, hey, thanks. That's really helpful insight. And I've just got one more question here for Sean. Now, I think I mentioned that Sean is in Kentucky, so we're going to attempt to get some insider knowledge from him. As you know, the Kentucky Derby winner was American Pharoah. So, Sean, is American Pharoah going to win the Triple Crown?
Oh, Joe, that's a tough one. Chances, I don't know. I mean, I watched him win the race, but last year, if California Chrome couldn't do it, I'm not as bullish on American Pharoah. But you can never go wrong placing a $2 bet for a Triple Crown winner.
There you have it. Everyone, take your $2 and head on out. Do it legitimately, though, right? You don't want to get in trouble with the state AGs.
Hey, Inspires.com. That's a Kentucky company. Inspires.com.
Hey, I really appreciate both of you being on with us. This is great insight, and it's always helpful for companies to get this, because it helps them to ensure their best practices, to take another look at their business and their products and services, and to make sure they're compliant. So thanks so much, Sean and Jessica, and I will turn it now back to Michael Luter.
Thank you. And Joe, thanks for those insightful questions. I think Joe was able to ask those kinds of questions because Joe himself served as the Deputy Attorney General of the state of Florida and was Chief of Staff for that office for several years. He also was an in-house lawyer who managed a significant challenge brought by 26 states against his then company, and managed that to a multi-state settlement that involved 49 states, in a kind of a bet the company litigation. So thank you so much, Joe, for your insight as well. And I wanted to tell folks that we do have a Q&A widget, which I think is displayed on the left of your screen, where you can ask questions during this program. Moreover, this PowerPoint presentation will be available at our website at Foley.com in the next few days, and you can get a copy of the slides there. Bios for our presenters are also available in the resource list widget that is in on your display. As a reminder, today's program is being recorded and will be available on Foley's website in the next couple of days. Next, I'd like to shift to our UDAP update, and this comes from two of our three authors, our principal authors of our Foley's Unfair, Deceptive, and Abusive Acts or Practices treatise that has been published by Bloomberg B&A in the Banking Practice Portfolio. This treatise covers and is a comprehensive overview of federal law covering UDAP in the consumer financial services area. The principal author of that is the co-chair of our group, the Consumer Financial Services Group, and also vice chair of our litigation practice, Marty Bishop. And helping on that in very significant ways were Rebecca Hansen and Tom Hardy, who are both senior counsel in our Chicago office. Rebecca and Tom are going to give us the current update, and if Marty would like to chime in at any point, I'm sure he'll do so. So, folks, let me turn it over to Rebecca and Tom to give us a UDAP update.
Thanks, Mike. This is Tom Hardy. I'm going to kick it off, and then Rebecca's going to close it out here. So this is just sort of a general overview, not intended to be complete and comprehensive, but kind of summarizing some things that have happened really recently, particularly in the past couple of months even, the CFPB's enforcement actions and other things that they've done. And starting off, one of the interesting things that the CFPB does is puts out a lot of information about complaints that it's receiving, a lot of statistical information and breakdowns. And in its 2014 kind of wrap-up response report, it's interesting to compare what's happened over the last few years. They've received over 250,000 complaints in 2014. And from 2013 to 2014, the most changed category of complaints was debt collection, which tripled in the number of complaints. And now these debt collection complaints, so complaints about debt collectors, are 35% of their total complaints. So that's a huge increase from year to year. And with that increase, comparatively, mortgage-related complaints have kind of dropped off a little bit. And it's still the second greatest category of complaints that they're receiving, but it's definitely a lot less than it was in 2013. And the third greatest, it's not listed on the slide, but the third greatest category of complaints is credit reporting. And those have also jumped up in the past year a little bit as well. So we're seeing credit reporting and debt collection jumping up and mortgage kind of subsiding a little bit. One of the areas that the CFPB looks at is fair lending, and there's some indication that there's going to be a lot more activity in that space in the near future, but there's already been quite a bit. You can see in the 2014 annual report that was just put out in the last couple of months, over $224 million was returned to consumers last year for fair lending violations. And the Department of Justice just recently disclosed, among a lot of other information, so that it has 10 joint investigations regarding ECOA, Equal Credit Opportunity Act violations involving national origin and racial discrimination. And some of them, it's speculated, although it's not quite clear from the DOJ disclosure, might involve auto lending. And so you might see some enforcement actions resulting from these investigations in the near future. And certainly it's been and will continue to be a major concentration of the CFPB and the DOJ. One area that also looks to be a hot area is bank overdraft fees. The supervisory highlights that just came out in winter of this year, so just recently. It says that it noted that there's a calculation of overdraft fees based on non-settled transactions. So in other words, people are having their overdraft fees based on transactions that have posted but haven't been settled. And that's a change in a lot of practices that the CFPB is viewing as increasing the likelihood that consumers will incur fees that they didn't bargain for. And so this is something they've noted. They haven't actually, there's definitely going to be some activity in this area, it seems, from what they're saying, because they're definitely, this supervisory highlights concentrate on this quite a bit. And it's definitely interesting reading in general about what CFPB is looking into and what it might do in the future. But just recently, on April 28th of this year, the CFPB filed a consent order, filed an action for a consent order, saying that the bank violated the overdraft opt-in rule. It was charging overdraft fees to consumers who hadn't bargained for opt-in coverage. And on top of almost $48 million that had already been refunded, this order is going to require this bank to pay an additional $7.5 million penalties plus refunds of additional overdraft fees. So that's a significant area of concentration as well. And so RESPA anti-kickback actions, this is sort of a duo of cases or enforcement actions. In January, there's a complaint against 2 banks plus a former bank officer and his wife regarding alleged kickbacks that violated RESPA. Then in April, just recently, another complaint against a title company and 2 of its executives. So these are basically the same kinds of transactions. The 2 sides of the same transactions here. So the title company on one side and the bank officers on the other. And Director Cordray has said just about these specific actions that this should serve as a warning to all those in the mortgage market. Well, if he's saying that, that means that look out because there'll be more of this in the future. And one of the things that's very interesting about this is just the individuals who are being named in these complaints and these actions. And we just saw, I think just yesterday or the day before, an action filed against 2 loan payment processing companies, as well as the owner of those 2 companies, seeking a judgment for deceptive practices as well. So you're seeing a lot of executives and employees of these companies also being brought into the enforcement actions as defendants. Now, one of the things that's kind of interesting just recently happened on May 1st, there's a consent order filed against a land developer. The allegation being that the land developer had misrepresented to purchasers that roads in the development were completed and county approved. And the CFPB, through this consent order, ordered the developer to actually fix the roads. And the headlines were all basically CFPB orders developer to fix potholes. But this is sort of an interesting, expansion of the jurisdiction or authority and scope of the CFPB's reach. And I think we're going to see some more of this kind of thing in the future. And now I'm going to kick it over to Rebecca to finish out the rest of this update.
Thanks, Tom. I'm just going to quickly touch on some of the other major areas that the Bureau is focused on. The first being debt collection. Debt collection is an area that hits all of the Bureau's high areas of interest. You've got people generally who are in a financially vulnerable situation. You've got people, parts of that population are people who they're not native English speakers or don't have a high degree of education. And the Bureau is very focused on these groups and how marketing and servicing to these groups plays out. And last month, actually, the Bureau took action, as they have been doing very regularly, against a loan servicing company because they were using false threats, multiple phone calls, and improper methods for debt collection. Another area that the Bureau has been very focused on are payday loans. The Bureau is looking at, they're working on a new set of rules for payday loans. Again, this is an area that hits the populations that the Bureau is very focused on. They're looking to impose new rules that would prevent situations basically that put the consumer in a debt trap where they are just in a cycle of debt and can't get out of that cycle. Students have been a huge area of interest for the Bureau. We heard our guest speakers talk about the for-profit institutions and the interest in those. The Bureau's cracked down on representations that are being made to students in the loan process. Recently, they cracked down on misrepresentations that were being made about the impact of students participating in the federal student loan rehabilitation program. The Bureau is very active on campuses trying to make sure that credit cards being aimed at students are vetted and making sure that students are getting the information that they need about them. So they're going to continue to be interested in that area. And they actually also, they ask parents of students to, put your complaints on our website. Let's get everybody talking about it. And it will continue to be an area of interest for the Bureau. And in addition to that, the Bureau has been very focused on the military and our service members. The Bureau recently took action against a company that processes military allotments for service members, and that's a system by which service members are able to deduct payments directly from their earnings so that they can then send money back home, for example, or pay their bills. The company was found to have charged undisclosed reoccurring fees, and they did it in a manner so that it was very hard to detect because the money kept being deposited into the account and the fees were just kind of eaten up little by little, and it added up over time. So the Bureau cracked down on that company. The Bureau is very focused on, making access to financial products easy for service members because they have additional burdens of, trying to get a spouse, that's in another country, have access to their accounts and whatnot, that type of thing. They're trying to make financial products easier for service members. And finally, the Bureau is likely to take aim at arbitration clauses very soon. We've all entered into some sort of agreement for one thing or another that contain arbitration clauses, and many of us don't even read them, don't know they're there until an issue arises. The ability to challenge those agreements is very difficult as well. And the Bureau noted that about roughly half of all credit card and checking accounts are subject to arbitration clauses. And of course, the Bureau has been investigating this area and is obviously not convinced that there's a consumer benefit to those and is looking at regulations to curb their use. So those are the major areas that the Bureau has been focused on that we're seeing enforcement actions rising out of. And if you have any questions, we welcome them, and I will pass the phone back to Michael Luter.
Thank you so much, Rebecca. We have gotten some questions in that we would like to address. I don't know that we can get to them all, but we have a question here that the question is, are the debt collection complaints more relative to third-party collectors or first-party collectors? Do the AGs look at the two, first and third-party collectors, differently? And Joe, I don't know if the AGs are still on the line and can supplement my answer here, but I would like to share something with you, and that is, first off, debt collection at the federal level has always been covered by the Fair Debt Collection Practices Act, which is a statute that specifically excludes the original creditor from coverage. Many states, though, in their own debt collection laws, will include the original creditor. So many of the prohibitions that we see at the federal level apply at the state already via those state laws. The CFPB has also expressed a desire to, an intent to issue the first ever regulations under the Fair Debt Collection Practices Act. And in its pronouncements about that, it seems rather clear to me that they're seriously considering not literally extending the Fair Debt Collection Practices Act to original creditors, but using their UDAP authority to, in essence, make those same rules and restrictions applicable via the UDAP authority. So in other words, the regulations will come out. They will cover original creditors under UDAP authority, third-party debt collectors under the Fair Debt Collection Practices Act, and in essence apply many of the same rules. The agency, the Bureau, is obviously very concerned about debt collection practices in America and believe that some of the culprits are original creditors, and we expect action on that sometime this year or next. Joe, any insight from you or the AGs on the how AGs are looking at those two items, third-party and first-party collectors?
Yeah, Mike, I think we completed our section, so Sean and Jessica have already dropped off the call.
Okay, I thought that was probably the case.
Yeah.
I would like to talk to, just a few more minutes, though, Joe, about your work. As the AGs told us, oftentimes they will gather together to go after a company or a practice on a kind of a nationwide basis. And would you share with the group what it is that a company should do and think about when they're not targeted by an individual AG, but by many or several AGs?
Yeah, sure, Mike. So, one thing that I hoped came out of the discussion we had today is that AGs are motivated equally by legal issues, by policy issues, and by politics. 43 of the 50 AGs are elected officials. Certainly AGs are well positioned to run for governor and U.S. Senate. They have their own particular interests that would have motivated their campaigns in the first place, or things that they get attracted to, such as the Kentucky AG going after the for-profit college space. So when you think about approaching an attorney general, you need to consider all three of those elements. If you're just going in on the legal issues, you're really missing what might be the public policy that's driving an investigation, or you might be missing the political angle that could help resolve that particular issue. So with multi-states, in large degree, that just gets multiplied out. So now you have those motivations, times 10 or times 15 or 20, but they're each, even though there may be a similar legal issue they're pursuing, doesn't mean all of those AGs are having the same motivations. And so having the ability to get in there and pick that apart and figure out how do you satisfy each of their concerns is really the goal. My practice is among the 50 state attorneys general, so I know most of the state AGs personally. I've been in this world for over 8 years now, and so I know some of the things that motivate those AGs. I certainly represent companies, under investigation, but also another way to influence them is getting in before your company is under the microscope, and that is, having someone that's gathering intel from the AGs on what issues they're looking at, someone who's speaking to the AGs about your industry or maybe even about your company and educating them, building champions so that if something does hit, you've got an AG or two in place who will pick up your phone call and will put the brakes on something until you get your side of the story in. That's important work. I know a lot of companies do that in terms of Congress, or they might do that in terms of the state legislature affecting the laws. And you can have a similar type of influence and access to AGs on the front end, and it's something worth thinking about, particularly if you've got business in a large number of states.
Thank you so much, Joe. Folks on the line, I wanted to mention to you that we have another program next week on responding to government investigations, whether it be a state AG or a CFPB or another government regulator. We're going to do that on the 21st, May 21st, at noon Central Time. The target, this is being put on in conjunction with our for-profit university practice, but it really has general applicability. Our partners, Lisa Knoller and our senior counsel, Jen Keys, who are very active in these government investigations, will present kind of a best practices presentation on that. And anyone's interested in signing up for that, you can go to Foley.com and go to the Consumer Financial Services page, and you can, under events, find that upcoming event and register for it. And we encourage you to come. I think it will be a good program. Anything else from any of the other folks on the line? Oops, we just got another question, which is, hello, is there CLE credit for this? I think we have made application for that. Is that right, David?
Hey, Mike, I think that's something we'll have to check into and get back. I know different states, have different criteria in terms of the number of lawyers that are involved versus non-lawyers, so maybe we can get back to them on that.
Right, great. All right, everyone, thank you so much for your time, and that closes out our program for today.